Well, welcome everyone. We are letting folks make their way in from the waiting room, and we will get started in just a moment. Welcome, welcome. Thank you to everyone who is joining us live for today's Lunch and Learn, Power to Protect, SCOTUS Attacks on the EPA and Federal Regulatory Agencies. And thank you to everyone who is joining us by watching the recording on YouTube. We are glad to have you with us. The U.S. Supreme Court has been captured and corrupted by far-right special interests, including the fossil fuel industry. They are attacking our environmental protections and our rights. One of the most dangerous trends at the court is the right-wing supermajority systematically taking power from agencies like the Environmental Protection Agency, agencies that protect people from powerful special interests, and transferring that power to unaccountable judges with ideological agendas. That is terrible news. But what's great news is that we have a phenomenal lineup of top-notch judicial advocates joining us today to lay out what exactly the Supreme Court justices are up to and how it is affecting our environment, our rights, and more. We are delighted to welcome Doug Lindner, Senior Director of Judiciary and Democracy at the League of Conservation Voters, Chelsey Davidson, Policy Counsel at Take Back the Court Action Fund, and Persis Yu, Deputy Executive Director and Managing Counsel at Protect Borrowers Action. Thank you all for joining us today. My name is Kathleen Neal. I am the Senior Director of Policy and Partnerships here at Maine Conservation Voters and Maine Conservation Alliance. Our organizations represent more than 13,000 members and supporters dedicated to protecting Maine's environment and our democracy. MCA does that through education, collaboration, and advocacy, and MCV by influencing public policy, holding politicians accountable, and winning elections. Since 2020, this weekly online Lunch and Learn series has helped us advance all of those goals, creating a shared space to explore our environmental and social history, policy priorities, climate action movement, and more. A few notes before we dive into today's program. We'll hear from our speakers first and tackle your questions in the Q&A session at the end. You don't have to wait, though. You can send those questions to me through the chat whenever they occur to you. I'll compile those questions, synthesize the ones with similar themes, and ask as many of them as possible following the presentation. We ask that you not message speakers directly, as we want their focus on the presentation, not the chat box. If you do have any technical challenges today, you can message Maggie Summers, and she will help you out. This event is being recorded, and the video will be posted on our website later this afternoon. You can also find recordings of all of our programs on YouTube, where we have a number of playlists to help you focus in on particular topics. Thank you again for joining us. And Doug, I will turn it over to you to start things off.
Thank you very much, Kathleen. Thank you to everyone at Maine Conservation Voters for hosting, and to everyone watching live or online, and especially to my fellow panelists, Chelsey and Persis. I think we're going to have a great session here, and also just want to say to the people of Maine how wonderful your Maine Conservation Voters folks are, and how much I love this Lunch and Learn series, which I've seen so many wonderful programs happening over the years. And so let's get into it. I'm going to try to share my screen if I can deal with technology properly. Okay, I think that's working. Someone let me know if it's not. I'm going to go back to the beginning of my slideshow, which I did not do right now. Okay, so as we're getting into this, I'm going to talk a little bit about what our Supreme Court has been up to on the environment in the last year or two, and what to expect in this next Supreme Court term that is about to start, because the Supreme Court works on a sort of a school year. And what the broader pattern is that we're looking at in these things. I know for some folks, talking about courts or what the Supreme Court is doing may seem a little dry, but I promise it's not, because this is so much bigger than legal doctrine. This is about the balance of power in our democracy and the future of environmental protection. So let's get into it. First, why do courts matter to the environment? Environmental law is one of the most complex areas of law in America, and as you may notice, we have some complex areas of law in this country. Some of the most important authorities in environmental law are the Clean Air Act, the Clean Water Act, the Endangered Species Act, and there are also state environmental land use and other laws. There are many moving parts. Administrative law, which exists at the federal, state, and local levels, but we're going to talk about it at the federal level specifically here. Administrative law, even beyond the environment specifically, plays a huge role in deciding what the EPA and other agencies can do. Administrative agencies are sort of the core of the New Deal, of the ability of government to protect the people from powerful special interests and unchecked markets and big business who want to do things that are not always in the best interests of the people beyond those profiting from it. So the Administrative Procedure Act is a key federal law underpinning all of these agencies. We're going to talk a little bit about a core doctrine called Chevron deference that is key to the ability of agencies to lead the way in terms of interpreting the laws that they work on. State administrative law is also relevant here. We won't get into it today. And it's important to keep in mind as we go through all of this, how much incredible power that courts, but especially the United States Supreme Court, have over public policy in this country. They have the power to interpret, apply, uphold, and strike down laws, policies, practices, regulations in particular, and essentially to say no to agencies when they don't like what the agencies are doing, or sometimes even to compel agencies to do things that they don't want to do. So let's get into it. We are going to talk here primarily about the U.S. Supreme Court, but I just want to briefly mention there are, of course, other courts that are relevant to these things. The D.C. Circuit is another federal court that's sort of the second most powerful court in the nation that also oversees the EPA and other federal regulatory agencies in terms of reviewing many of their actions. And of course, other federal courts, state high courts, and other state and local courts also have quite a bit to say on environmental policy generally. So recently at the Supreme Court, two big cases that have happened over the last, let's say, 16 months that I think are worth keeping in mind as we go through this. One is last year's West Virginia v. EPA. Now, this was a major case that was wild for a lot of reasons that I could spend a whole lunch and learn session and have spent a whole lunch and learn session talking about. I'm sure that is on our friends at Maine Conservation Voters YouTube page. But the short version of this is the justices manipulated the law in a number of ways in order to allow themselves to substantially roll back the most important authority the executive branch has to fight climate change, which is EPA authority to regulate climate pollution from power plants under the Clean Air Act. And they did this under a vague, made-up thing called the Major Questions Doctrine. Remember that phrase because you're going to keep hearing it today. The Major Questions Doctrine is a thing that has no real basis in the Constitution or anything passed by Congress, but it is something that the right-wing justices have made up in recent years and actually used that phrase for the first time in West Virginia v. EPA. And essentially it says that when a federal regulatory agency does something that's just too big a deal, the Supreme Court might say, that's too big a deal. If Congress wanted you to do that, they should have said more specifically that they wanted you to. And when they use this, it is nearly always to stop a policy that a Democratic administration wants to do that is popular with progressives and unpopular with Republicans. It is also extremely hand-wavy. It is profoundly unprincipled, even though in theory it is a legal principle. So that's West Virginia v. EPA, and it's not great. More recently, just this May in Sackett v. EPA, the Supreme Court had another decision in which so West Virginia v. EPA is about climate and the Clean Air Act. This one's about the Clean Water Act. And it removed Clean Water Act protections for most of the wetlands in the United States, which has massive, massive implications in terms of clean drinking water, in terms of the health of our communities, in terms of the businesses and fishing and everything else that relies on clean water. And because wetlands are a critical protection against flooding, it also exacerbates the way the climate crisis will impact our communities as well. And both of these things have disproportionate impact on communities of color, which bear the greatest burden of all kinds of environmental injustice. Justice Elena Kagan, an Obama appointee who I think is fair to say is the most ideologically moderate justice on the court right now, has said about both of these cases that the vice here is the court appointing itself as the national decision maker on environmental policy, which is not how government is supposed to work in a democracy, and yet that is what's happening. It's also worth keeping in mind as we go through all of this that threats to democracy, including from the Supreme Court, are also threats to the environment. And the Supreme Court has been doing quite a lot to undermine our democracy, frankly. They have been striking down voting rights, striking down campaign finance laws, upholding voter suppression, upholding gerrymandering, and on the whole, it's not great. So what's coming up in this particular new case? So the Supreme Court every year starts their term on the first Monday of October. They have not scheduled oral argument in this case I'm about to talk about yet, but it is coming in the next few months. And it is called Loper Bright Enterprises v. Raimondo. Now, in theory, this is a case about who pays for compliance monitors that are required by law on commercial fishing boats, whether that's the commercial fishing companies or the government. But that is sort of the context in which the court has decided to give itself the opportunity to consider a massive attack on the New Deal. Because this could overrule a bedrock principle of administrative law called the Chevron Doctrine. This comes from a case from the mid-1980s called Chevron v. NRDC, and essentially it says that when a federal statute is administered by an expert agency, the way the EPA administers the Clean Air Act and the Clean Water Act, and there's some ambiguity in that statute, courts are supposed to defer to the agency's reasonable interpretation of what it means. This is one of the most important legal precedents in all of American law. It comes up in court more often than Brown v. Board of Education, more often than Roe v. Wade, more often than probably literally any other court case you can think of. I'm a lawyer. I don't think I could come up with a court case that comes up more often than the Chevron Doctrine. But they have decided, because the justices decide which cases they want to hear and what questions they want to consider, they have decided to consider getting rid of the Chevron Doctrine. So what does that mean? Let's back up a little bit. When we think about the design of our democracy, the design of our institutions, we think about the executive, legislative, and judicial branches, federal, state, and local governments, separation of powers between those branches and between the different levels of federalism, checks and balances in which they keep each other from getting too powerful. And the idea behind this incredibly complex design of our hundreds of year-old system is that presidents come and go, members of Congress come and go, governors and legislators come and go. Sometimes people we agree with will control any of these institutions, and sometimes people we disagree with will control them. And that dynamic, that sometimes we agree with them, sometimes we don't, is so fundamental to the way that we and the institutions themselves look at this balance of power. And so regardless of how you would think about the balance of power between regulatory agencies and courts, 10 or 20 years ago, the fact that there is now a 6-3 MAGA supermajority on the United States Supreme Court is so fundamental to what it means when they attempt and successfully are shifting power from the agencies to themselves. Because they have a 6-3 majority, because they have life tenure, and because the justices themselves, knowing who controls the court and who will control it for generations to come, understand which faction benefits when they take power for themselves, which is the far right, it is the fossil fuel industry, it is the authoritarians, and it is all the other interests that aligned to help Donald Trump, Mitch McConnell, and their allies capture this court. So they're shifting power to the court from not just the scientists and subject matter experts at agencies like the EPA, but also from the Congress that was elected to create those agencies, from the president who was elected to run those agencies, and from the voters who elected them. So the MAGA justices can take that power for themselves and use it, again, to serve the interests that help them capture the court. At the same time, again, they're undermining democracy, which entrenches right-wing power even further. They have life tenure, and some justices serve 30, potentially even 40 years. Clarence Thomas has been there over 30 years already, and he's still in his mid-70s. He's got plenty of time. And the justices can, and often do, strategically retire when their side is in the White House to perpetuate their majority even longer. And there are lots of other threats to democracy coming, some involving the Supreme Court and some that don't. Also, a brief note that Republicans in Congress are trying to get rid of the Chevron Doctrine at the same time that the court is considering this. This is not just about administrative law, getting rid of Chevron. This is the latest example of a corrupt, unaccountable judges working to roll back the New Deal, the Great Society, and so many other hard-won victories that generations of environmentalists, progressives, and civil rights activists have achieved to protect the American people from wealthy and powerful special interests over the last century. It's about protecting everyone on the wrong side of the MAGA ideology that dominates this court, and it's worth keeping in mind that federal regulatory agencies impact everything we care about, not just the environment and not just this massive list of other issues that I put up on your screen, and I won't run through all of them here, but if you, breathe air, drink water, enjoy eating meat that has been tested as opposed to not, so many other things, regulatory policy affects all of them. And these agencies were created to protect the people from powerful industries that do not want the people to be protected from them because it hampers their ability to do whatever they want. The problem is also bigger than one case. And I want to be clear that I'm not predicting any particular outcome in this case, because even if the court decides not to do the wrong thing in this particular case, the pattern remains. The pattern is already in place. It's already happening. Remember West Virginia v. EPA and Sackett v. EPA, the big clean water case last year, and the big Clean Air Act on climate last year, and the clean water case this year. Remember the major questions doctrine, in which the court is already giving themselves the power to hand wave and veto regulations they don't like. Remember, they're going to keep doing it because they have this agenda, and they're going to keep doing it regardless of the outcome in this case. And they're breaking democracy with their judicial power. The right-wing justices, as I said, trust the court to achieve their policy goals because they know each other. They know they have this 6-3 majority, and they know, as studies have shown, that if nothing changes about the structure of the court, it is likely that no lawyer alive today, even 25-year-olds, will live long enough to see this majority displaced. We at LCV support expanding and rebalancing the court to address that, but the assumption that the justices have for now is that judicial power is right-wing power. Part of the implication of this is agencies trimming their sails in the face of the major questions doctrine and potentially losing Chevron and the vagueness of those threats. So if you're an administrative agency and you want to do something to protect the American people, you want to do something to implement the law that Congress has mandated you with implementing, to make that policy, and the court is hostile to what you're doing, you might do something less ambitious. You might not go as far. You might not do some things that you think in good faith you should do, that you should have the legal power to do, but the court are bad faith actors and you can't trust them to allow you to do your job. It also means, because litigation takes a long time, running out the clock on progressive administrations. This is what happened with President Obama's signature climate regulation in 2016. They implemented it in 2015, the second to last year of the Obama administration. It got held up in court in unprecedented ways. And eventually, while it was still pending in litigation, there was a change of administration, and the Trump administration got rid of it. And so the Obama Clean Power Plan never went into effect because these judicial threats to administrative agencies, in addition to what the decisions might be in various cases on various regulations, just knowing that you can tie these things up in court for so long and might get a decision that is against the agency is helpful to those who want to run out the clock and prevent these things from going into effect. It means voters getting less of what they vote for when we vote for folks like Joe Biden and Barack Obama. It means shifting power from the public interest agencies to the industries they regulate, who are involved in the scheme to capture the court, who have more political power in light of Citizens United and other massive ways that corporate power and money impact our politics. And of course, all of this is happening against the backdrop of threats to voting rights, of gerrymandering, and of authoritarianism, all of which are aligned against the people, against our environment, and in favor of the authoritarians and their allies in the fossil fuel industry. So I will leave it there for now. Appreciate everyone joining and your questions, and looking forward to the other panelists.
I think, Chelsey, am I next? Am I up?
You're next, Persis.
Okay. Hello, everybody. Thank you so much for having me here today. I'm Persis. I'm with Protect Borrowers Action, and I do not have as robust of a slide deck to show you. I could listen to Doug all day talking about court reform, but thank you very much. So I'm with the organization Protect Borrowers Action, which is the C4 arm of the Student Borrower Protection Center. We launched Protect Borrower Action in the wake of the Supreme Court's decision in Nebraska v. Biden, which is, of course, the case that struck down President Biden's attempt to provide student loan debt relief to 40 million student loan borrowers across the country. As in my capacity at the Student Borrower Protection Center, we had led the amicus effort to get, organizations and progressive groups to file amicus briefs. We had over 12 different briefs representing
over 100 organizations file at the Supreme Court. And a lot of them were student loan and consumer protection groups, but we also had progressive civil rights groups, we had labor groups, we had veteran groups. We had a lot of different interests filing at the Supreme Court. And I think one of the things that's interesting to note is if you look at the opposition briefs, is that a lot of the folks who filed in opposition to President Biden's plan are also some of the same folks who filed opposition amicus briefs in the Loper case that Doug was just talking about. And so I guess I'll launch into a little bit of the why, what is Nebraska? Why do you care about it? And then also talk about some of the upcoming cases in our consumer protection world and why I think you all should be interested in this. So, Nebraska v. Biden, it was one of two cases challenging President Biden's use of the HEROES Act. The HEROES Act is the statute under the Higher Education Act, which provides that the Secretary of Education can take measures in a national emergency to protect student loan borrowers and other folks in the financial aid realm from the negative financial effects of the national emergency. And so the statute is quite broad. It allows the secretary to waive or modify any provisions of the Higher Education Act in order to provide this relief to the student loan borrowers. So President Biden had relied on this law in order to provide cancellation to 40 million student loan borrowers because student loan payments have been paused due to the pandemic. And what a lot of economic analysis has shown, and previous emergencies have also shown, is that there is a lot of economic devastation when you resume payments after a pause. And so what the president was doing based upon using the HEROES Act was attempting to relieve those economic burdens of what would happen when the federal student loan payment system resumed payments by providing this cancellation, which would have buffered those economic harms. So that's kind of the basis of what the secretary did. And the Supreme Court, there were two cases. And I mentioned the second case too, because I think it's important in this broader context of corruption and what is happening here, right? So the first case was Brown versus Education, which I don't think is an accident in terms of the name of the plaintiff that they found. I'm pretty sure that they really were excited about being able to say that this was another Brown versus Department of Education. But setting that aside for the moment, this is a right-wing funded lawsuit. And it was funded by an extreme right-wing organization that had been recruiting student loan borrowers, looking for months, even before they filed their challenge, for months, even before the president made his announcement about debt cancellation, looking to challenge this. And so it happens to be run by the same guy who I think owns Home Depot too. So for anyone who is doing any home repair, to keep that in mind. But so this right-wing organization searched high and low for plaintiffs, and they found two plaintiffs, and Brown and Taylor, who are student loan borrowers who did not who one of them actually was entitled to student loan relief, but not the full relief. Because for those who were not following, the way that the program was structured is that borrowers under certain income thresholds got $10,000 of debt relief. If you got a Pell Grant, that would entitle you to an additional $10,000 of relief. So one of the plaintiffs in this case had received $10,000 of relief, but she didn't received the Pell Grant, so didn't get the additional $10,000. The other borrower was a borrower, but who had loans that weren't eligible for the program. And so these borrowers filed these lawsuits funded by a right-wing organization because they were complaining that they didn't get enough debt relief, right? And so one of the things that shows is just that how preposterous, right? This right-wing organization, in order to strike down a program, is saying that actually these borrowers wanted more, but because they didn't get more, nobody gets it. And because they filed in Texas, a Texas district court judge invalidated the entire program, went beyond went beyond the injunction that was being filed in that moment to invalidate the entire program and shut it down nationally. And and then of course that went to the Fifth Circuit, which is one of our least favorite circuits here, which upheld that and made its way all the way up to the Supreme Court on what is, I think, what most reasonable folks agree is one of the most laughable standing arguments and legal arguments. In fact, most people were kind of laughed this case away when it was first filed, thinking it was just so ridiculous. But here we are, that this is actually the case that had the effect of shutting down the program first. The other case wound up being is Nebraska v. Biden. And so the Nebraska case is 6 states filed jointly based upon, again, kind of like wild and crazy arguments of standing, where they claimed for various different reasons. One were that if people have less debt now, then they're not going to have more debt in the future forgiven, and therefore they're going to receive less in tax revenue, was one of the arguments of standing that they used. Some of these states have the Family Federal Education Loan Program, which is a defunct loan program, but that still collects money from people. And some of the states have associations with those FFEL lenders because they used to be the ones who originated the loans. And then the one state, Missouri, which is kind of the key state here, because in the state of Missouri, there is the servicer Mohila. And Mohila was also a FFEL lender, and so they have their origin story there. It was created by the Missouri State Legislature, but it is its own independent nonprofit that can sue and be sued on its own name, has its own budget, has very little financial ties to the state of Missouri, but it was created by the Missouri State Legislature, and they have a federal student loan contract. So they service federal loans for the entire country on behalf of the Department of Education. And what the Missouri AG argued was that if loans are canceled, Mohila's loan volume will go down, which means that Mohila will make less money. And therefore, the state of Missouri, which created this, would not get the money, but created this entity, has standing now to challenge the legality of this program. And the thing that is really astounding about the case, so first of all, the district court level, in a Republican appointed judge at the district court level in Missouri said no, that was not sufficient standing. It was then challenged up to the 8th Circuit, which kind of issued this injunction without any kind of explanation, and then it went up to the Supreme Court. And so we get to this place where the Supreme Court has now decided that, yes, based upon Mohila, they don't really talk about the lenders and they don't really talk about the tax issues at all, but they talk about Mohila as this one lender, because they're going to lose money and lose loan volume, and because there's some kind of connection that the Supreme Court doesn't really get into, the state of Missouri has standing and challenges it, and has standing to challenge this case. And they then launch into a discussion. They invalidate the program because, using a very kind of loose statutory interpretation of waive and modify, which are the key words under the HEROES Act. Somehow waiving doesn't mean waiving, because that's never what we meant by waiving before. So there was a very loose statutory interpretation, but then they go into the major questions doctrine again. So we see again the use of the major questions doctrine come up, and invalidating the program because, again, it's just too big, right? We know that it was a political question. We know people don't like it. And so it just must be too big. And so I think like Doug was talking about before, we see basically the major questions doctrine being the tool that is being used because, as best as I can tell, Roberts just really doesn't like the idea of student debt cancellation. He talked about how big it is, right? It costs $400 billion over 30 years, which is a large number, admittedly, but the student loan portfolio was 1.7 trillion in this exact moment. I don't even know what the 30-year, total balance would be. And so, but like 400 billion is not actually that, relatively not actually that big of a number. And so we saw the major questions doctrine being used. I mean, I think everyone should care about this case because I think people should care about student loan borrowers. I genuinely believe that, debt is actually a barrier to many of our, I live here in Boston. I'm very concerned about like my neighbors not being able to go to college and solve the fact that we're going to be underwater in a couple of years. But aside from, the more general kind of like, we're all interconnected here, I think that there is a really, like, there's a couple things that people should be very concerned about. I mean, I think first of all, the major questions doctrine is a thing that should put us all on alert, because it is just the court saying, we control public policy when we don't like it. And that is very dangerous. And I think, the use of, the way that they have used standing also is very dangerous because it's picking and choosing who can challenge these laws. And I think that's the piece to talk about. And how is that this company is entitled to a profit, right? Like, thinking about, I mean, I am not a constitutional scholar, so I'm not probably the best person to articulate the rules of standing and why it exists. I will say that as a consumer lawyer, I will say that it's often used against consumers. It's often used to keep consumers out of courts. But it has also been used as a tool, as a lever to say that these people are entitled to the courts, right? And so now, basically, the state of Missouri has been granted by the Supreme Court basically veto power over any kind of administrative action that President Biden is going to take. And so I think this is a piece that really does keep me up at night, beyond the student debt fight, but that there is nothing that our administration can do where it's not going to worry about whether or not Missouri is going to like it and is going to take it to court. And I think that it really does have the potential to create a place where our Department of Education doesn't feel like it can do its job. One of the things I want to highlight from the oral arguments, is that Justice Kagan, again, one of the more moderate members of the court, said that the court is, tasked with deciding very complicated issues every day and looking at complicated, issues of statutory interpretation. And the HEROES Act wasn't one of them. That it was very clear under the HEROES Act that this was a waiver, waiver and modification under the HEROES Act, and that the court just didn't like it. So I want to say that, and I realize I'm like going way over my time, and I want to give time for Chelsey. I want to flag also that the CFPB case that's coming up. Because I think it's also really important for folks to pay attention to. The CFPB issued a payday lending rule in 2017, and that has been challenged by the Payday Lending Association, by a trade association basically. And this gets us to the Fifth Circuit, which has not invalidated the rule because of they challenged the rule on a number of different grounds. Most of them were thrown out. But the thing that then happened was the Fifth Circuit ruled that the entire Consumer Financial Protection Bureau is invalid because of its funding structure. The way that it's funded is it is independently funded outside of the normal appropriations process. It is funded through and now I'm sorry, I'm blanking on the technical term of what it is, but a number of our consumer protection agencies are funded under this mechanism. And it grants, and it was very intentional on the part of Congress when it set up these federal agencies. So it's not just the CFPB, it's the FDIC and other basically independent oversight entities are funded through these independent means to kind of take them out of the political process, right? So that Republicans can't come in and defund the CFPB when it decides that it wants to hold banks accountable. And so this is another case that is coming up. It does have oral arguments scheduled. I think it's October 3rd is the date. So folks should look out for that. They should look out for, the talking points, share on Twitter or whatever that social media site is now. Because I think one of the things that's really important for folks to think about here is the way that we hold corporations accountable. And I think that this is one of the through lines that where all of our different issue areas kind of intersect, is about corporate accountability, and making sure that we have the mechanisms, and the federal government has the mechanisms and the authority that it has, in my opinion, been granted by Congress to hold corporations accountable and write rules that are protective of our citizens. And so I think that is threatened right now. And I'm going to stop there. I have all sorts of other things to say too, but I want to make sure that Chelsey has her time.
Thanks so much, Persis. I know that we're already running over, but I hope that the audience can make some time to hear a little bit about potential solutions to the threat that the Supreme Court
definitely
poses.
want that, Chelsey. You take your time. There is
Okay.
We have all the time in the world for solutions.
All right. Well, then I will start my little pitch. So I'm Chelsey Davidson. I'm policy counsel with an organization called Take Back the Court. We are the only national organization dedicated exclusively toward court expansion as the solution to the threats that the Supreme Court poses. I wanted to go a little bit into the ethics scandals, but I will try to summarize very, very succinctly what's going on. The Supreme Court has made the public completely and rightfully question who they're accountable to, who they owe favors to, and the ways that they're going to rule in favor of their Republican donors rather than toward what the law reflects and what the American people have expressed through a democratic process, what they actually want. And complying with ethics doesn't just mean avoiding actual corruption. It means even avoiding the appearance of corruption. And that's something that's really, really important. Among other very notable occurrences, it seems like week after week, we get these breaking ethics scandals about private vacations, jets, paying for your mom to live in someone else's house for years, paying, donors paying for family members' college tuitions of the justices. The list goes on and on and on. But one very notable environmental relevant instance was the fact that Justice Thomas, just a few years ago, went on a vacation in the Everglades on the estate of one of the largest land and road developers in Florida. Now, Florida is 31% wetlands, and just this past June, he voted alongside other Republican appointed justices to erode protections for 50% of the nation's wetlands, as Doug has covered. So in just the past couple of years, the court has issued litany of decisions that are eroding Americans' rights. Persis covered some of the education equity cases. Doug has covered the environmental ones, but I want to just give us a very high level scope first. They've attacked reproductive rights and ended the right to an abortion in Dobbs under the guise of states' rights. This term, they're likely going to hear a case related to FDA approval of an abortion medication, which would end the availability of that mode of abortion in all 50 states if it succeeds. They've overturned a 100-year-old gun safety law in New York. And this term, they're going to hear a case challenging the ban on people with domestic violence restraining orders obtaining guns. They've attacked democracy. They've shredded the Voting Rights Act, one of the cornerstones of the civil rights movement, for the better part of a decade in multiple cases. And this year, they're going to hear a case that could prevent victims of racial gerrymandering from bringing claims in federal court. They also ended affirmative action in college admissions, and they are likely to, in the next few years, take up a case that would go even further to K through 12 admissions and potentially even environmental zoning, public housing, etc. And they prevented 46 million Americans, including me, from obtaining debt relief that we desperately need. So just a high-level summary of the Supreme Court shows us just how corrupt they are, just how much they are divorced from what the American people want. And I want to talk about how we got here, because this didn't happen overnight. This was a concerted effort. So let's just go back a few years to 2016. In an unprecedented move, Republicans in the Senate, led by Mitch McConnell, refused to even give a hearing to the Supreme Court nominee that Obama put up, Merrick Garland. By doing so, they shrunk the size of the Supreme Court to 8 seats for more than a year. And they did that without going through the legal legislative process. So after stealing that seat and under the guise of, well, the voters deserve, a say in who sits on the Supreme Court, a couple of years later, they're like, forget about that. Forget we ever said that, because now we have an opportunity to steal another seat, right? So they pushed through the nomination of Amy Coney Barrett after 63 million people had already voted in the 2020 election that would ultimately unseat Donald Trump. These two moves are insidious, they are ridiculous, but they are very, very transparent that this is an intentional theft of the Supreme Court. Without those two moves, instead of a 6-3 MAGA Republican majority, we would have a 5-4 narrow liberal majority on the Supreme Court, and you would not be seeing these types of attacks on democracy, on reproductive rights, on civil liberties and freedoms. You would not be seeing that. But in 4 years, they successfully captured the court. And beyond that, they have held one-party control of the Supreme Court for more than 50 years. And political scientists predict that without reforms like court expansion, they are at a minimum going to hold the court until 2065. That is 42 more terms of these types of decisions that we've seen in just the last couple of years. We cannot survive that. Our democracy cannot survive 42 more terms of this type of action. Fortunately, the Supreme Court there's nothing special about the number 9, right? We've had as few as 10, or as many as 10, as few as 5 or 6. And Congress has actually acted to change the size of the Supreme Court more than 7 times in our history. Half of Mount Rushmore expanded or shrunk the size of the Supreme Court. This was a very common checks and balance that has been used across different centuries. Even the declaration of the intention to expand the Supreme Court saved the minimum wage law back in the 1940s during the New Deal era. And it is an important tool that Congress must use again. In the last 5 years that Take Back the Court has existed, we have really, really taken court expansion from a pipe dream into a reality with a bill before Congress, 65 members of Congress already co-sponsoring the bill. We have over 150 organizations now publicly supporting expansion, and we have leaders like Eric Holder, Elizabeth Warren, very vocal advocates for expansion, now realizing that this is doable, it is necessary, and it's achievable once we have a governing window, but we need to be building that momentum now. So by adding 4 seats to the Supreme Court, which is the Judiciary Act, we would be able to counterbalance all of these threats to our civil liberties. And we would also be able to put in a fair practice for appointments, such as term limits, ethics reforms, and other really, really necessary metrics to have a fair and accountable judicial system. Now, unfortunately, the Supreme Court, in particular, Sam Alito, have announced that they should be unaccountable to Congress. And unfortunately, you can't install those types of reforms to create a fair process until you have a Supreme Court that recognizes that it is a co-equal branch of government, not a unilateral authoritarian state. And to do that, we simply need to add 4 justices to combat those 2 thefts. So what are we asking for you today? Well, lower courts also have an outsized importance in the everyday lives of Americans. You've heard how the 8th Circuit and the 5th Circuit blocked student debt relief. That's going on all over the country with dozens of different cases every single day. And so what we're asking of you today is to call up your senators, both of them, and ask them to confirm Biden's judicial appointments across the country. It is so important that while we work on building momentum to expand and rebalance the Supreme Court, that we're making sure that lower courts, their vacancies are filled now, and that they're doing the work that everyday Americans want them to do. Because unless the Supreme Court chooses to take up a case The final word on cases is typically those lower courts, those circuit level courts. So it is very, very important that you take action, that you call these senators and you let them know how important it is that those vacancies get filled now. I'll leave it there for questions. I know that we're really over time, but I hope that that was helpful and informative.
Oh my goodness, so helpful and so informative. Thank you, Chelsey. Thank you, Persis. Thank you, Doug. That was the whole journey, right? The like overwhelm, despair, fired up, ready to go. Thank you for bringing us along on that. And I'm sure everybody heard Chelsey's terrific call to action to reach out to Senator Collins and Senator King to confirm judicial nominations, and also to, so you know, to keep an eye out for the Supreme Court ethics bill that will be going through the Senate this session. Later this afternoon, you will all get a follow-up email with a link to this recording and the contact information for our senators' offices, so that it'll be super easy for you to just pick up the phone and let them know this matters. Not sure if everybody knows this, but the senator's staff keep track of those phone calls, and the senators get a weekly readout of who's calling about what. So if they see a little bump in, wow, people are really thinking about the judiciary here in Maine, they notice that, and it does make a difference. So thank you for your advocacy. We've got a bunch of good questions. You can keep those coming to me through the chat. And we will tackle as many of them as we possibly can. Chelsey, I'm going to start with you because it's so fascinating. Your organization is dedicated to Supreme Court expansion as the solution. And I really appreciate that clarity because sometimes we hear, you know, there's a whole menu of possibilities and we could try this or we could try that. Can you let us know why that solution, the size of the court, is so important? And by the way, I'm going to be quoting you on the half of Mount Rushmore has expanded. That is gold. So thank you.
You're welcome. So I think that it's not that the size of the Supreme Court is what matters. It's the rebalancing element, right? And I do want to say, yes, we have a menu of options, but I think that it would be a mistake to put our weight as, you know, progressives, as Democrats behind those other options now, because frankly, it takes tremendous political power to get these bills through. And ultimately, the Supreme Court is most likely going to hear cases related to those bills, and they are most likely going to overturn them. Because they can and they are not incentivized to give up any of the power that they have built decades stealing for themselves. That's just a reality check that I think that the people need to understand. Like, I did not originally envision myself as a court expansion advocate. Like, I was in law school, I was learning about the Supreme Court. You know, I had grown up with this idea that we haven't touched the size of the Supreme Court in 100 years, you know, all these ideas. And then the reality is that court expansion is the only constitutionally proven and repeatedly done way of checking and balancing the Supreme Court when it does get out of hand. Like, that's the reality. So I went into these ideas thinking maybe term limits seems like a more moderate approach. Well, frankly, term limits comes with some constitutional questions attached to it. And I think that regardless of whether it's constitutional or not, I believe that this Supreme Court will overturn term limits. I think another Supreme Court that believes that it should be checked and balanced and that it is accountable and a co-equal branch of government would likely uphold those types of systematic reforms to make the process fair, right? I don't want to live in a world where we have to wait around to see when someone's going to die or when they're going to preemptively retire in order to have an appointment process. I want it to be regularized. I want it to be attached and accountable to the American people. But the reality is we cannot do that with this court. We need to rebalance the Supreme Court before we can have a court that believes it is ethically accountable.
Can I just briefly say, 100% agree with everything Chelsey said. We at the League of Conservation Voters are totally aligned with our friends at Take Back the Court on this issue and about what it's going to take to solve the problem.
Thanks, Doug.
Here. Yes, thank you very much. I really appreciate that. And that reminder that we actually have to get ahead of the Supreme Court a little bit on this, because they have the power to reject any of these reforms.
Absolutely. And at minimum, we just need to play defense, right? This isn't happening in a vacuum. Republicans have already stolen 2 seats on the Supreme Court. Like, that's the reality. We're not starting from, a neutral playing field, a tabula rasa, thinking what is the most fair way to appoint justices to the Supreme Court, right? We have more than 50 years of ground to make up, and we need to actually, at a minimum, be playing defense so that we can build a court that works for everyone and get ahead of it.
A lot of times when we as advocates talk about the action that we want to see at the federal level, we talk about local action, community, state level action as the sort of incubator for that, or the proving ground. And we say, yeah, it's hard to see how you fit in at the federal level, but you can make a real difference in your community tomorrow. How does that apply when we talk about the judiciary? Because I know that state courts matter. We're involved at MCV in a coalition called Courts Matter. we try to educate folks about that all the time. But what is the connection, or where is the disconnect between local action and federal action in the judiciary?
So I can jump in briefly, but happy for others to speak to this as well. I think that part of the disconnect is that people sometimes think that courts are a thing that only lawyers care about. And I can see why people would think that. It's certainly, how I might have thought of it before I went to law school. But you have 3 lawyers here telling you this United States Supreme Court is not a court of law, it's a court of power. And it's something that is coming, that we need our third branch of government, like the first 2, to be protecting our rights and our environment instead of attacking them. So that's one. We need people to care about it and get engaged. It's not just for lawyers. It's not just for people who want to dig in on Westlaw and read all these opinions. It's about the substantive policy impact that these people are using their power to achieve or block. I think that people need to understand the power that individual citizens and voters have to impact our courts at every level. Your calls to your senators, asking them to confirm Biden's judges to those lower courts, as Chelsey was saying, that's a really important thing. We really need you to do that. It does make a difference. It has an impact. So please call your senators and tell them to confirm Biden's judges. In terms of other courts, it isn't, as Chelsey said, the U.S. Supreme Court hears relatively few cases. They're big, momentous cases, but there's less than 100 cases a year that they hear. The vast majority of cases in the federal system, even just in the federal system, are decided finally in the circuit and district courts, which are also very powerful lifetime appointees, by the way. The last I checked, the last 10 presidents all still have appointees still serving on the federal bench, going back, to like Kennedy and Johnson, still have judges serving. And then we think about the state courts as well, also incredibly important. Most states have some form of electing judges. My understanding is that Maine is one of the few that does not, as a New Hampshireite, that is very familiar to me. And so in Maine, your judges, I believe, and I hope my Maine friends will correct me if I'm wrong, your judges are appointed by the governor and confirmed by the state senate. Right. So one of the ways, super important things that you can do to ensure that your state judiciary in Maine is protecting your environment and your rights is voting for pro-environment governors and pro-environment state senators. And those elections have enormous consequences, not just in terms of who holds the governor's office and the legislature, but the judges they appoint and the policies they will implement. And by the way your state constitution is interpreted in the long term. These are all incredibly important things. And the role of state courts in protecting our environment and our rights is only enhanced the less we can trust our federal courts to do that.
And if I can just jump in here, and just kind of like step back and think about how we got here. right? How did we get to this place of having such an unbalanced court? And it's not a thing that just happened overnight. This has been a very concerted effort on the part of the right wing. And, they started at the local level, right? Like a lot of this starts at the local level in state legislatures, in gerrymandering, I think the right has been very, very sophisticated in their understanding of how to use the local level to trickle up, to get to a place where we now have a Supreme Court. This is, many decades in the making. And so I think, there is a proven track record of understanding that what we do on the local level makes a big role in what happens federally. And I do just also want to echo this call for, appointing judges. Like I said, the reason that we got where we were in the student loan cases is because there was a judge in Texas, and we know there's more than just one judge in Texas, and we know that there's right, and that we are ceding power to these single judges to roll our entire federal policy. And so I think the strategy by the right wing has been a very local level, and I think that progressives need to learn from that and do our part as well.
I'll just say that if there's any upside or silver lining to having such an obviously corrupt and horrific court, it's that I think that everyday Americans are finally really understanding that the judiciary really affects your life. It affects what you're able to do, the rights that you have, the air that you breathe, the water that runs through your faucet. All of these things are unfortunately really dictated by courts. And I think that what I hope is that, one, we can all fix this together. But the second thing that I hope is that it lives in institutional memory, that when you are voting for things like president, you're voting for sometimes hundreds of judges at the circuit and lower court level, the district court level, and that those judges beyond the Supreme Court have an outsized influence on your life. So it's really, really important to consider not only the candidate, but the type of person that they're going to put on that bench. And right now, they're going to put that person on that bench for up to a lifetime appointment.
I have so many more questions, but I feel like the three of you just tied it up perfectly. And Chelsey, I really appreciate that reminder that when we go to the polls, we're not just voting for a candidate, we're voting for a view, an understanding of the way our systems should work, could work. All of those hundreds of appointments, it all matters. And I'm so grateful to you, Chelsey Davidson, to Persis Yu, to Doug Lindner for being with us today. Everyone, you will get a follow-up email with a little bit with that nudge to make those calls. Let our senators know how important this issue is. It touches everything. So thank you.
Kathleen, can I just offer one last item for our friends who are watching this on YouTube and won't get the email? If you didn't get this email, and by the way, even if you don't live in Maine, anyone who lives in any of the 50 states, you can reach your senator's office by calling the U.S. Capitol switchboard, and I'm going to give you the phone number right now. It's 202-224-3121. Call that number, tell them where in the United States you live, and they can connect you to your senator's office.
Doug, would you repeat that for me one time so I can put it in the follow-up email?
202-224-3121.
Doug, I love that you can rattle that off. I'm not surprised, but I am impressed. And little hack for everybody, if you were listening or when you get the email, put it in your phone. You can just say, call my senator, and Siri will help you out. So thank you for that.
Doug scares me sometimes.
Just to let everybody know, we're going to be at the Common Ground Fair this time next week, and we hope that you will be too. If you are, please come find us in the Environmental Concerns tent. We will have our 2023 environmental scorecard very close to in hand, and you can see how your lawmakers voted on issues that affect our environment, our communities, climate, democracy. We'll also have postcards available for you to send yourself a little reminder to vote, because we do have elections coming up in November, and there are 8 ballot referendums. We've got a lot to say about it. Come chat with us. One of the questions we'll be talking about is question 6, which will require the reprinting of the Maine Constitution to include all provisions, including the state's obligation to the Wabanaki Nations, which have inhabited Maine since time immemorial. That is a perfect little teaser for the next Lunch and Learn that we will have back in this space on September 29th, featuring Penobscot Nation Ambassador Molly-Ann Bryant. She'll be here to walk us through that question and the broader movement for tribal sovereignty in Maine, which I know so many of you are active in, and we're really grateful for that. Lots of good work to do. Absolutely phenomenal company with which to do it. So thank you to everyone, and we will see you again soon.
Thank you, Kathleen. Thank you, MCP. Thank you, Chelsey and Persis. It's been great.
Thank you guys.
Thank you.